The paper we're discussing starts out by talking about the development of both substantive due process doctrine and incorporation doctrine. So before 1947, these two doctrines were really one doctrine. And the doctrine focused on protection of fundamental rights under the Due Process Clause of the 14th Amendment. The idea was that the 14th Amendment protects individuals from infringement of their fundamental rights by state governments, and that federal courts have a role to play in enforcing those rights against state governments. Remember, in the US, we have a system that divides power between the federal government and the state governments. For a long time, the idea was if I want my rights protected against state governments, I look to state courts and state law. If I want my rights protected against the federal government, I look to federal courts and federal law. But applying the 14th Amendment Due Process Clause basically got federal courts involved in using the federal Constitution to protect individuals from infringement of rights by state governments. So in the early 20th century, the court really focused a lot on economic rights as fundamental rights. And then there was really a major revolution in the US in the 1930s that scaled back federal constitutional protection for economic rights. And that left a small number of rights protected under the 14th Amendment Due Process Clause, but frankly, not a whole lot. So then 1947 is a critical turning point because in that year, in a case called Adamson v. California, Justice Hugo Black proposed this idea of what he called total incorporation. And the basic idea was that in his view, one of the main purposes of the 14th Amendment was to incorporate the Bill of Rights against the states. So what that means is the Bill of Rights is really the first 8 amendments to the Constitution, and there are a whole range of rights protected there. Originally, it was understood that the Bill of Rights limits the federal government, but does not apply to the state governments. So his idea was that the 14th Amendment made all of those provisions in the Bill of Rights, the first 8 amendments, binding on the state governments. And that was known as total incorporation. But the Supreme Court never actually bought Black's idea of total incorporation. And instead, what happened is in a whole series of decisions between about 1948 and 1971, the court engaged in a process that has come to be known as selective incorporation, where one by one, and it wasn't just amendment by amendment, but really clause by clause of particular amendments, the court says, this clause of the 6th Amendment is binding on the states. This clause of the 8th Amendment is binding on the states, et cetera, right? And by the time we get to 1971, most of the rights in the Bill of Rights are binding on the states under this doctrine known as selective incorporation. Meanwhile, there's a revival of substantive due process doctrine that begins in the 1960s, but whereas the old substantive due process doctrine in the sort of early part of the 20th century focused on economic rights, modern substantive due process doctrine that really gets going in the 1960s focuses on privacy and autonomy. And so under that doctrine, we get protections for the right to use contraceptives and ultimately protections for abortion rights. And most of modern substantive due process then really focuses on abortion rights, which are protected under the 14th Amendment, basically from 1973 until last year when the court decided Dobbs, right? Meanwhile, incorporation doctrine really stops in 1971, and nothing happens with it until 2010. And then in 2010, in a case called McDonald v. City of Chicago, the Supreme Court says, well, the Second Amendment is binding on the states under incorporation doctrine. And McDonald was a pretty revolutionary decision because for more than 200 years, state and local governments had been free to enact whatever gun control measures they wanted, free from any federal constitutional constraints. And now all of a sudden in 2010, the court says, well, the Constitution actually limits the power of state and local governments to enact gun control measures. Excuse me. And that 2010 decision in McDonald is an important precursor for the court's 2022 decision in Bruin, which puts further restrictions on the ability of state and local governments to enact what I would consider reasonable gun control measures. And so we get these two cases coming down in June 2022, which are Bruin on guns, which limits the power of state and local governments to enact gun control regulations under so-called incorporation doctrine, and Dobbs on abortion, which frees state and local governments to enact restrictions on abortion. Originally, before 1947, substantive due process and incorporation were really both treated as a single doctrine. And they're both based on the same text, same constitutional text, which is the Due Process Clause of the 14th Amendment. The Due Process Clause of the 14th Amendment says, no state shall deprive any person of life, liberty, or property without due process of law. And although on its face that sounds like a procedural protection, it's been generally understood since at least the 1890s that particular constitutional provision also provides substantive protection. There's some basic, rights of life, liberty, and property that are so fundamental that governments may not infringe those rights regardless of what process they use, right? So this is the core idea of substantive due process, and it's also, frankly, the core idea of incorporation doctrine. And both doctrines are concerned with trying to determine what are those fundamental rights that state and local governments may not infringe, how do we determine those rights? So the court today, when the court is trying to figure out what are fundamental rights, it's got these different linguistic formulations that sort of set a standard for what qualifies as a fundamental right. But if you look at the linguistic formulations the court uses for that, it's basically the same test for what qualifies as a fundamental right under incorporation doctrine and what qualifies as a fundamental right under substantive due process. So the ostensible distinction between the two is that incorporation protects what are called enumerated rights. Substantive due process protects what are called unenumerated rights. Enumerated meaning the right is spelled out explicitly in the text of the Constitution. Unenumerated meaning it's not spelled out explicitly in the text of the Constitution. So it is true that the Second Amendment talks about, the right to bear arms. There's nothing explicit in the text of the Constitution that talks about the right to have an abortion or even the right to privacy. So from the court standpoint today, they sort of, favor judicial protection of enumerated rights. They disfavor protection of unenumerated rights. And that's why we get, gun rights coming out one way and abortion rights coming out a different way. But in fact, that distinction is more illusory than real. So the court's most recent so-called incorporation case is a decision in 2020, which held that the right to a unanimous jury verdict, which is protected under the Sixth Amendment, is binding on state governments. But that's not actually an enumerated right. There's nothing in the Sixth Amendment about a right to a unanimous jury verdict. right? So the court treats that in its doctrine as an enumerated right, but it's actually, I mean, the Sixth Amendment does talk about a right to a jury trial, but there's nothing in the Sixth Amendment about a right to a unanimous jury verdict. And the court had previously said that right is not binding on the states because it's not spelled out in the Constitution and states can do what they want. And then in 2020, the court changes its mind and says, this is binding on the states. And they say they're applying incorporation doctrine, which in theory is applying enumerated rights, except this is not a right that's spelled out in the Constitution. So why does that count as incorporation, whereas abortion counts as substantive due process? It's sort of an arbitrary distinction. The main test the court uses these days to determine what rights are fundamental rights is a historical test. And they're looking for rights that are deeply rooted in the nation's history and tradition, right? But the test is, in my view, sort of theoretically incoherent. And here's why. Because when the court decides that X right qualifies as a fundamental right, the main consequence of that is they are transferring decision-making authority from state legislatures to federal courts. So consider McDonald and gun rights as an example, right? For more than 200 years, up until 2010, decisions about the scope of protection for gun rights, or the right to bear arms, right, were made by state legislatures and derivatively by local governments. And federal courts didn't interfere. When the court decides that gun rights are a fundamental right, effectively what it's doing is it is transferring responsibility for transferring decision-making authority from state and local legislatures to federal courts, right? Now, they try to justify that by history, but, you know, the history is very clear on this, that for more than 200 years, that power to make those decisions was vested in state and local governments, right? And there are two possibilities here. One is that state and local governments are all basically providing the same protection for gun rights. And if that's true, then the only thing you accomplish by transferring authority from, you know, elected legislators to unelected judges is you transfer authority from elected legislators to unelected judges. Why should we do that, you know? And if there's actually a variety of state and local laws on the subject, which was the case sort of before McDonald, right, one of the foundational premises of our constitutional system, well, two foundational premises of our constitutional system. One is that we divide authority between state governments on the one hand and federal governments on the other hand. And two is that we have a preference for decision-making by democratic bodies because they're elected rather than decision-making by unelected judges, right? And so, and that allows for different legislatures in different states to make different judgments about what's the right level of protection for gun rights and what are sensible controls and restrictions on guns, right? And the court invokes history to wipe all that away, but how does a history of, it makes no sense. It's sort of illogical to say that a traditional history that divides this power among the 50 states supports a decision to concentrate that power in the Supreme Court. The history doesn't support that, and yet they say they rely on history to sort of make that decision. So the historical test just cannot, even in whatever the history shows, the historical test cannot even in theory provide a coherent theoretical justification for the main thing that they're doing here, which is transferring decision-making authority from state legislatures to federal courts. For 1947, the court was really looking more at natural law principles. And I do think that, at least in theory, that makes sense, right? The Constitution itself includes a provision, the Ninth Amendment, which says basically that, look, the rights spelled out in the first 8 amendments are not the only, important rights, right? There are other important fundamental rights too. And substantive due process doctrine sort of recognizes that. And in fact, when there was a revival of the doctrine in the 1960s, at least some of the justices really wanted to base it on the Ninth Amendment and the idea in the Ninth Amendment that there are fundamental rights, that if we have, if we want to preserve a system of government, which we can loosely refer to as sort of liberal democracy, there have to be limits on the power of government to infringe, we could call them inalienable rights, we could call them fundamental rights, but there's this idea rooted in natural law that all of us as human beings are endowed with certain inalienable rights or fundamental rights that, if we really want to say that we live in a system of free government, government may not infringe those rights. So I think that idea is very intuitively appealing to a lot of people. The problem is always, well, who gets to decide what those fundamental rights are, right? If we talk about abortion, right, there's one group of people who think the fetus has a fundamental right to life. And there's another group of people who think the woman has a fundamental right to control her body, right? So who's going to be the sort of umpire who mediates between those two really conflicting visions of what qualifies as fundamental rights? And for a long time, we left it to basically state legislatures to figure that out. But in the sort of modern era, post-World War II, I would say, there was an increasing tendency to look to courts as sort of umpires to resolve those disputes, right? And what is really interesting, so a lot of my background is in international human rights law. And I undertook a project actually several years ago to look at the court's incorporation doctrine in light of international human rights law. And what you get is a series of about 15 or 20 cases, as I said, between 1948 and 1971, where the court is selectively saying, this right in the Bill of Rights is incorporated and therefore binding on the states. This right in the Bill of Rights is not incorporated and therefore not binding on the states. And what's interesting is those decisions line up really, really nicely, not perfectly, but very closely with, well, is it in the Universal Declaration of Human Rights or not? If the right is there in the Universal Declaration of Human Rights, well, it's incorporated, it's binding on the states. If it's not there in the Universal Declaration of Human Rights, it's not incorporated, it's not binding on the states, Now, the court never actually said that this was what it was doing, but the court during that period had a vision of fundamental rights that really aligned with the vision of fundamental rights that's there in the Universal Declaration of Human Rights. And to me, that vision is very sort of morally appealing, and I think the doctrine is defensible on that basis. Notice then, and I think we're probably running out of time, so I'll sort of close with this, that under any, if you look to, what I propose in the paper is looking to a combination of international human rights law and comparative constitutional law to determine which rights qualify as fundamental rights. And I think this move makes sense because it does provide an objective test so that courts are not merely applying their own personal subjective preferences, but courts are looking to objective standards to determine what rights qualify as fundamental rights. And whether you look to international human rights law or to comparative constitutional law, gun rights clearly do not qualify. And therefore, in my view, the court's decision in McDonald to make the Second Amendment binding on the states was wrong, and that decision should be reversed. The situation with abortion rights is more complicated. International human rights law is fundamentally ambiguous on abortion rights. You can find support in international human rights law for the woman's right to choose, but you can also find support in international human rights law for the right to life of the fetus, right? So it's a little hard to come to a definitive answer on that. I did look then not just at comparative constitutional law, but comparative law more broadly. And what's interesting there is this is one of the few rights, like I have in the article tables that list a bunch of different rights and have, different analysis. We won't go into all the detail, but abortion is one of the few rights where if you break the world into sort of liberal democracies and everybody else, right? The US is an outlier among liberal democracies in its, now post-Dobbs, right? This is just in the last year and a half. But since the court's decision in Dobbs, we're really an outlier among liberal democracies in not protecting a woman's right to choose. Most liberal democracies do protect a woman's right to choose, even not necessarily through constitutional law, some through statutory law, right? But most liberal democracies protect a woman's right to choose, and most authoritarian states do not. So the United States is sort of aligning itself with, authoritarian states here in the way it's approaching abortion these days. And I find that troubling.